have always been associated with companies as in-house counsel and have seen management perceptions which more or less is pro-settlement or discouraging litigations, right? So in my view, no company would encourage litigation unless it is inevitable. Company will certainly have a list of cases filed by and against company, but they predominantly will be happy to find solutions and reduce net value at risk. And therefore, out of court settlements without much of compromising company's interest, considering time and cost, are always welcome, in my view. The role of legal department is, let me tell you, no longer limited to this managing legal risk associated with the business, but now they work around them. So like, now effective legal team now need to partner with businesses, understand their issues, and really expected to provide viable or tangible solution, and also be vigilant to avoid litigation to the extent possible. Our standard clauses on dispute resolutions are sacrosanct. And subsequently, with the amendment to SIAC rules, with the introduction of ARB clauses, they have now become a part of our standard templates. So that is how the mediation is coming into picture now.
Oh, thank you. So let me just elaborate a little bit on that. When you talk about the ARB clause, what we are saying is that when the parties have a dispute, they first bring the matter to arbitration.
Yes.
And after the matter is admitted by SIAC and the panel is constituted, the matter automatically comes to SIMC for mediation.
Yes,
within a period of 8 weeks. If it is settled, excellent. If it's not settled, it goes back to SIAC for arbitration.
Yes.
It was a very smooth one-stop process where you basically have the best of both worlds of both arbitration and mediation.
Earlier, we had this fantastic case somewhere in 2016, where arbitration was invoked against us, and it was pertaining to coal purchase contract. The claimant was energy and commodity seller based in UAE, and we were respondents in that. The dispute was about quality of the cargo on parameters that were agreed. So there was a discrepancy between the terms agreed during business confirmation and those appearing in the signed contract that was drafted by the seller. And then we rejected the cargo. And of course, that is where the seller went into the dispute and invoked arbitration. Let me tell you, the speed at which proceedings were handled was really commendable. I mean, we received this arbitration invocation notice in December 2016. Then subsequently, the parties agreed to mediate somewhere in mid of April 2017. And by 19 June 2017, the mediated settlement agreement was reached, signed, done and dusted. Yes. I would rather see the mediation as a win-win situation, because what happens that there is one party who is aggrieved and the other party who has to defend the case. And that, so when a party goes into mediation, and when the matter goes into mediation, it really both of the time is given to both of them to prove their own sides, right? And the mediation helps in solving the dispute in a faster way. As you have seen in our case, we could get the final award in 2 months' time, right? So that saves your time. And of course, the same effect is on a cost, because the number of hearings or whatever are lesser. So cost and time saving really gives the peace to the management, and everybody is happy at the end, because mediation is something which is not forced. Both parties have to agree. So it is a consensus or conscious decision taken by both the parties to part away with the X thing that they agree in the mediation process. And that's why I really see that there are all plastic sticks to this agreeing to the mediation process. So yes, low cost solution and the flexibility with edible, then you have a cultural understanding also, proximity. So all these benefits are certainly coming out of mediation.